All right. Thank you everyone for joining us tonight. I'd like to give a warm welcome to Stuart Saft and Ajo Korean, who will be our panelists tonight alongside me, Elise Rosemarin. I'm a Senior Vice President here at AKAM. Joining with me tonight, we have Stuart Saft. Stuart Saft is a partner and he is at Holland and Knights, New York Real Estate. He is a practice leader there as well as a co-chair of the firm's global condominium development and conversion team. He's written 40 books, not just only on real estate, we've learned, on commercial real estate, and more than 100 articles on real estate, economics, and finance. Mr. Saft also is the author of the 3-volume Commercial Real Estate Workouts, which is now in its 3rd edition. Thank you, Stuart, for joining us tonight.
Thank you for having me.
Thank you. And then Ajo Korean is a Senior Vice President here at AKAM. He has working knowledge of every facet of residential building management, and his understanding of the needs of property managers, owners, and residents has been critical to AKAM's clients throughout the COVID-19 pandemic and the recent flurry of new regulations like the one we're going to discuss tonight, helping AKAMs manage properties, interpret guidelines, and incorporate them into today's day-to-day and long-term operations and procedures. All right, thank you, gentlemen.
Thank you.
So tonight, we're going to be discussing the Reasonable Accommodations Law and giving you an overview and exactly what this is and what this all entails now. So this is a moving target. Tonight is going to be part 1 probably of what evolves into a situation in the end, but we do want to touch base. We do want to offer guidance at this juncture. And so Stuart, we'll start with you. So the Reasonable Accommodations Law jumped into the forefront of everyone's mind last week, but the New York State Division of Human Rights has been working on this since December. So can you give an overview and the purpose of this law?
Well, the law itself, not having the broader law, not just what came out 2 weeks ago and then over the weekend, the broader law is intended to provide individuals who are disabled in any way with the ability to participate in society the same as people who have a full use of their facilities and their body. What's mandated is that if someone has a handicap, and there's a whole list of what's included, landlords and owners have to make reasonable accommodations for them. They don't have to rebuild the building in order to enable somebody to get through the front door if there are steps, for instance, but they do have to put in a ramp or find a way to facilitate the handicapped individual from being able to get in and out of the building or to be able to use the public amenities in the building. And the issue is always, what is a reasonable accommodation? And there's always a dialogue between the individual and the landlord or the board, and not infrequently it winds up in front of the Human Rights Commission, because not providing reasonable accommodations is a violation of the affected individual's rights. What brought this all, and this has been the law for probably a decade, and what's brought all this to a head was that in the 2nd week of March, notices came out from the state saying that every landlord and co-op boards, including co-op boards, would have to send a notice to all of the tenants in the building by on or before April 1st, which is of course tomorrow,
Right.
and give notice to any future tenant of the obligation of the landlord, including a board, to make reasonable accommodations for any kind of a disability. And so we were racing around we were racing around for the last 10 days or so to try to figure out what this meant, because there really were no guidelines at all. And then all of a sudden, over the weekend, we learned that on Thursday afternoon, Governor Cuomo signed into law a replacement of the bill that had previously been the basis for the notifications to all of the residents. And the new law basically provided that there was going to be a process that the Human Rights Commission would have to come out with regulations, and that the regulations would have to be published and open for discussion. And then 60 days after the regulations came out, 30 days after they were finalized, then the notices would be sent out. So although the old law that provided for notifications on April 1st is in fact still in play, the Human Rights Commission announced that they wouldn't be enforcing it or doing inspections because no one really knew how to apply this and the extent of which the notifications had to be given. So there was a lot of confusion, and I'm rather amazed that during the budget season, somehow the budget was put on hold and they went in this other the state went in this other direction. But probably in 6 weeks or so, we'll get copies of the division's regulations, and then we'll have a better idea of what it is landlords have to do in order to comply.
And so, sorry, I don't know if you heard me correctly. I sound a little bit like a monster. Now I think I'm okay. Who does this, I apologize, it wasn't me being a villain. Who does this apply to, just to get the basis of who this law will apply to, and if you expect any changes as to who it applies to?
Well, the law applies to it applies to all landlords, mm-hmm. and it's applicable to existing tenants and prospective tenants. So initially, all tenants will have to receive a notice indicating that the law provides that they have the right to get reasonable accommodations from the landlord, and the concept of landlord includes co-op boards, but doesn't presently include condominium boards. And the provision is that the landlord has to provide reasonable accommodations with regard to the public portion of the building, the amenities, the front door, the lobby, where the mail is, garbage disposal, but that the tenants or the shareholders are responsible for reasonable accommodations within their apartments. And in the past, we've seen tenants go to the Human Rights Commission to complain that there's something in their apartment that they feel the landlord should be responsible for, and we've seen this happen with co-ops also, and sometimes the landlord is required to do something in the apartment in order to make it accessible. In most instances, the co-op boards are not required to do any work in the apartment. Sometimes you have tenants or shareholders who insist upon it, and the board will go ahead and do the work and then bill the cost back to the shareholder, and they don't quite understand why they got a bill, but it's only because the law doesn't require a board to do work in the apartment.
Interesting. So from a management perspective, Ajo, how are management companies such as our own AKAM, how should we be preparing our clients for this?
Sure. the establishment of protocols and procedures around the regulations once they come out are absolutely necessary and critical. From the April 1st deadline and whatever that established regulation is, and then the ongoing notices that need to go out. We were actually queued up to send out the disclosure notices prior to April 1st. And then we pulled it back once we heard, as Stuart mentioned, what happened over the weekend. And the other thing that I would say is important for us and for our client boards is that we should really treat each request as in a case-by-case basis, right? I don't think that buildings should publish and establish or try to publish and establish policy around what any of the new regulations are, just because of that issue with interpreting it incorrectly and that being used against the building. And then, of course, have your building's legal counsel involved. And the procedure should be that the request should come to the management executive or the manager of the property, and then that should immediately be brought up to the board, and then include legal counsel at the same time, document everything, and just kind of cover all the bases in that regard.
Yeah, that makes sense. So someone would like to know, does this apply to a holder of unsold shares who is a subtenant in the co-op?
It's unclear at the present time as to what the responsibility is and whether or not the owner of the apartment would be considered a provider of housing, although my best guess is that the regulations will require it, but that's one of many questions that hasn't been addressed as yet.
Is there any reason why, I mean, it sounds like that it just maybe was a lack of preparation, but was there any reason why all of a sudden they decided to amend the law only a few days before the notice was due to go out?
If there is, none of us know what it is. It just was a huge surprise. And as an attorney, as a real estate attorney, I was getting notices from all manner of people, other attorneys and other management companies. And a lot of the information in the notices that came across my desk were incomplete or inaccurate. So nothing that AKAM issued was incomplete or inaccurate.
Of course not. That goes without saying.
And so I was bewildered as to how anybody was going to comply with this by April 1st, and therefore greatly relieved when I was able on Sunday to send out a client alert to basically say, stop. You don't have to do this by April 1st. We're going to get detailed regulations, and then we'll have a better idea of what has to be done.
Yeah. Someone would like to know, oh, sorry, Audra, what were you going to say?
No, I just wanted to thank you, Stuart, because that was the memo that we received and pulled our release of the notices back. And that's the reason why. So I just wanted to thank you for that.
Thank you. Okay, so what is the definition of reasonable? Someone is thinking about a co-op city decision a few years ago and how costly it was to retrofit for a wheelchair access.
Well, it's a complicated answer, and there's been tremendous litigation over what is reasonable and how much something has to cost in order to merit being reasonable. And the place that we've seen it the most, it has to do with stairs and lobbies, stairs into buildings and stairs into lobbies. And we've basically seen that, and part of the problem is that with regard to stairs into the building or stairs in the lobby up to wherever the mail is or other locations, creates an architectural problem, because if you're going to put in a ramp, then you need the ramp to be a certain distance, uh, and that becomes a trip hazard for everybody else. So some buildings have basically redesigned their first floor and their lobby at huge expense in order to deal with this. And others merely have a porter or a door person bring out a portable ramp in order to satisfy the immediate needs of a tenant. The Human Rights Commission, of course, would prefer a permanent alteration to accommodate this, and the landlords would prefer a temporary one. And then, just to make it a little bit more confusing, this comes up with landmark buildings all the time, and the permanent alteration of the front of the building in order to accommodate wheelchair access, for instance, is contrary to landmarks preservation law. And we've had discussions with landmarks, and they're very accommodating if you have to put something in order to comply with the handicapped accessibility laws. There are you're right, there's also issues of having to make the elevators handicapped accessible for wheelchairs, and that can be extraordinarily expensive, particularly if the shaft isn't wide enough to be able to accommodate the wheelchair. And there's just not a lot that can be done in order to deal with it, because you in a pre-war building, for instance, you can't make the elevator shaft bigger. So it's a question of how to come up with something that's not going to require the landlord to spend $10 million to redo, the entire elevator shaft. And that's where this whole concept of a reasonable accommodation comes in. And of course, as I indicated, there's always a debate as to what's the level of reasonable. From the landlord's point of view, it's cost and aesthetics. And from the tenant's point of view, it is don't treat me like a second-class citizen. And we've seen cases where there were restricted access into the building, and the landlord took the position that someone, a disabled individual, could go in through the basement and go up the service elevator. And the Human Rights Commission came back and said that's not really reasonable. You're really putting a tremendous burden on this individual. And then there's complications, because some accommodations are helpful to somebody with one kind of a handicap, but are detrimental to somebody with a different kind of handicap. And this has to do with space. Probably the biggest issue we're seeing today in this idea of the needs of one group versus the needs of another has to do with the pet laws, because individuals are allowed to have a comfort animal, and we see it all the time on airplanes. And if they come in with a doctor's note, you can't even really challenge them in the process. The doctor's note alone is sufficient for them to be able to have the animal. The contrary position, though, is that you have tenants that have moved into no pet buildings because it's a no pet building, because they're either terrified of animals, especially large or aggressive dogs, or because they have allergies. And so then you have this competing interest of one group who has a note from a doctor saying that they need a comfort animal to be able to to be able to deal with day-to-day life. And on the other hand, you have someone who doesn't want to have a comfort animal and is terrified in their apartment if there's a dog, for instance, now living on the floor.
Right.
So it's these two competing issues that have to be addressed.
Mhm.
And nobody has yet come up with a good solution as to how to handle one group versus another.
Yeah, it sounds very tricky. And obviously, when figuring this all out, you will definitely seek a professional such as yourself, an attorney. But what other professionals, maybe Ajo, you can share, other than legal, should be involved, especially from a management perspective?
Sure. I think certainly the management company has to be involved in the design aspect of this from a safety perspective. And then, AKAM has an in-house architect that could, opine, but if you don't have one, and for all buildings, the architect engineer of the building should be involved to help, again, with the design of the accommodation. From what Stuart mentioned in terms of compliance with regards to ADA and also aesthetics and just plain functionality of anybody coming into the building.
Right. Someone would like to know, so, this sounds, it's obviously a mandate that's supposed to be reasonable, but it also sounds a little bit expensive. So I don't know, Stuart, if this is something you can shed light on, but, is there any potential grants or public funding that's being available, especially for buildings that are financially struggling, that can maybe help them pay to perform the work necessary to accommodate?
I'm sure there is,
Mhm.
but I don't know who to direct you to. In most cases, it's a combination of the managing agent who's had experience dealing with these issues and bringing in an architect who is experienced in how to solve these design issues. Notwithstanding what I do for a living, the lawyer is really the least important person in the process. Other than to raise the issue of the accommodation and or, either take a client to the commission or defend a client at the commission. This isn't something that should blow up into a major legal dispute. It really should be resolved amicably by the parties involved. There are also a lot of organizations that provide legal help for people who are handicapped and need the assistance of guidance so they don't have to hire expensive lawyers.
Mhm.
The reality is that both the city and the state and the federal, but in this instance, it's usually the city and the state, human rights commissions are basically in the business of providing guidance for the residents of the building who need to have a direction to go or to have guidance as to how they should proceed. And both the Division of Human Rights and the Human Rights Commission are very, very aggressive in representing the interests of those who are handicapped. And if the commission or the division determines that there's probable cause for discrimination, then the burden of proof turns against the owner of the building. And the owner of the building has to demonstrate that either they've taken reasonable accommodations or have attempted to solve the problem.
Mhm. So Ajo, again, it sounds like a management perspective is definitely needed here. What are some of the immediate steps a building should take in case, something like this is brought against them through the Human Rights Commission?
Right. We should absolutely put the building's insurance carrier on notice of it, specifically also the directors and officers insurance carrier as well. And then loop in the building's legal counsel, and then between the building's legal counsel and the carriers, typically the building's legal counsel would quarterback it from there in terms of response and defense.
Okay. So you mentioned that this applies to rental buildings and to co-ops, but not specifically yet to condos. So in turn, would this apply to condo owners who lease their apartments out to a tenant?
Yes, it would. We believe it would at the present time,
Mhm.
based upon the way the way the law is written,
Mhm.
speaking in terms of a housing provider. And it really depends upon the regulations. And
Right.
I think we're going to see regulations that are not, 2 paragraphs long. I think you're going to see 20, 30 pages, 50 pages of regulations, because this is such a complex area, especially with an aging population. And so many buildings in New York are have older people who are more in need of these services.
Yeah. So again, as this is evolving, this is now a situation that people need to take into consideration, especially with, transactions from maybe a transactional standpoint. So someone would like to know, if an applicant is wanting to purchase an apartment, possibly a studio, for example, and they'll obviously need an expensive accommodation, is there a way that the application can be refused without it being deemed impermissible discrimination?
If someone applies to purchase an apartment and they have to do a major renovation, which would be their expense, if the board turned down the buyer because of the work that they have to do in order to make the apartment, accommodate the apartment to their needs, they would get called before the Human Rights Commission very quickly.
Okay.
So, and it's a problem, and it's a problem that is not uncommon, because the commission, Human Rights Commission and Division of Human Rights, as I indicated, are so aggressive in protecting the interests of the individuals.
Mhm.
Stuart, would you suggest that buildings add to alteration agreements a question as to whether any of the improvements they're making are related to, a reasonable accommodation, or in that regard, so that the board is aware of that?
I think that it's a great question, and I think it opens a Pandora's box.
Yeah.
Because you could have the same problem you have now with the comfort dogs, because you have perfectly healthy people who are in no pet buildings and all of a sudden need to have a comfort dog 2 weeks after they move into the building. So they certainly knew they needed a comfort dog before. And if the landlord or the board can ask any questions about the disability. So if the application said, is this handicapped for a handicapped accessibility, the board or the landlord, primarily the board, because tenants don't usually do major renovations in their apartments, would not be able to turn it down, and they wouldn't be able to look into whether there's a need. What this notice provision is all about is advising tenants and shareholders that they have certain rights, and the rights in a co-op, frankly, in the rental building also, is that if a tenant or a shareholder wants to make their apartment handicapped accessible, it's their expense. And in a rental building, the tenant then has to return the apartment back to the way it was at the termination of their lease. So this is this is the reason that on Sunday I was so delighted to see that a law had been passed to provide some direction, because I had no idea how we were going to handle all of the issues that were going to come out of this, legitimate issues, but for the government just to say that you have to send a notice that says that there's a handicapped accessibility law and you have certain rights under it is just not enough. And I'm hoping that the regulations will give us more guidance as to how to deal with the issues that arise.
Mhm. So going back, you were mentioning pets. With regard to pets currently as it states, even though someone has a note from their doctor, what about if the dog happens to be a comfort dog, but it's a nuisance to those surrounding them? Is that a consideration?
Yes, absolutely. The dog cannot be a nuisance.
Okay, that's
And New York has an interesting pet law, and that is that if a building is a no pet building and someone brings a dog in and the dog is living with the individual for 3 months, then even though it's a no pet building, and this has nothing to do with the comfort dogs, even though it's a no pet building, the landlord, including the board, can do nothing about the dog after 3 months, unless, of course, the dog is a nuisance. And that also applies to comfort animals. If the animal is a nuisance to the other residents of the building, the handicap law does not force the building to keep the nuisance, the animal that's a nuisance, in the building. Now, true comfort animals are trained to accommodate the fact that they're living in closed circumstances, whereas what I believe some people do is they go onto the internet, and for some minor sum of money, they get a little vest for the dog that says comfort animal, and they get a note from their chiropractor, and they say, I have a right to have a dog, period. And although the landlord has the right to a small degree of investigation with regard to the animal, it's really not very much that they can do. But if that dog is, and I'm using dog because cats don't make that much noise or really bother anyone. But if the dog is whining all day long or barking all night long, then the building can move to have the dog removed. But of course, the resident would have the right to get another dog.
all right. So now, are modifications triggered by a reasonable accommodation request from the tenant, or do modifications need to be made regardless of spaces that aren't currently accessible?
I'm sorry, I'm not following the question.
Okay, I'll repeat it. All right. So are modifications triggered by a reasonable accommodation request from the tenant, or do modifications need to be made regardless of spaces because they're currently not accessible?
No. The tenant would have to, or a potential a tenant would have to ask to have the space made, to have an accommodation made in order to be able to utilize the space. There are groups that bring lawsuits with regard to public buildings on behalf of handicapped individuals who aren't able to get into the public building. And that's a different set of circumstances. But the ones that are most commonly seen have to do with entrance and exits to and from buildings.
So then would that, oops, sorry, it's that scary mystery monster. I'm kidding. But does that now apply to the common spaces of the building as well? Or is it again, it's not a generality, it has to be requested?
That does have to do with the common space
Okay.
in the building. Every tenant has the right to have access to the common spaces. And in point of fact, there are roof decks that haven't gotten approval by the city because there's no way for a handicapped individual to be able to utilize the roof deck if you have to go up a flight of stairs in order to get to the roof deck. And so there's been limitations placed on being able to use a facility if it can't be made handicapped accessible.
Interesting. Okay, so now if it applies, if this general rule now does apply to a condo unit owner, how would they get the condo association to implement a requirement for their tenant?
It's theoretically possible. You mean with regard to a public portion of the building?
I guess so, yeah.
Yeah, and they'd have to go to the Human Rights Commission with regard to that. And the handicapped accessibility law itself deals with this issue, although the notice provision only speaks in terms of housing providers. So at the present time, the notice provision does not appear to apply to condominiums, but that could change when we see the regulations.
Understood. Okay, so now are there any details around the nature of disabilities which are required to be accommodated? For example, if an individual claims to be noise sensitive, are they now entitled to demand that the hallway outside of their apartment can't be vacuumed by the building staff without prior notice? Or, traffic noises from the exterior that far exceed the noise of a vacuum cleaner in the hallway, are they able to make statements such as that? I mean, to what extent can an individual demand limitations on building operations under the handicap claim and reasonable accommodations accordingly?
We've seen people make complaints when elevators get replaced that the new elevator is noisier than the old elevator.
Mhm.
And we've seen complaints about noise coming from outside of the building. But those are just complaints from existing residents and not necessarily tied to a handicap. It has to do with the obligation of a landlord to provide for the quiet enjoyment of the apartment to the resident of the apartment. And the question becomes the extent of the landlord's responsibility. Certainly in New York City, a tenant cannot demand the landlord do something about traffic noise because they want to keep their windows open. And I certainly understand the desire to keep the windows open, but there's certain ambient noise levels that in a city of 9 million people you're going to have. But it's less a handicapped issue than it is just a general issue of landlord's responsibility to provide a quiet enjoyment for the tenants in the building.
That makes sense. So for all future alterations that are now going to be, in essence required, can the board require that the alterations be compliant with the new reasonable accommodation requirements? They can kind of preemptively tackle this.
So are you asking that I'm making a renovation to my apartment? Are you asking if the board can say to me, you have to make your apartment handicapped accessible because the next person who buys your apartment may need it that way? And the answer is no.
Okay.
But if the board decides to, and if the lobby of the building doesn't have a permanent way of accommodating a resident being able to get in, the board can come up with, or the landlord can come up with a temporary measure, such as the building staff putting out a ramp. But if the building lobby is being renovated, if the building is being renovated, if the elevators are being renovated, then the landlord has to make the public portions of the building handicapped accessible. So until you go and do a major renovation, you don't have this problem. That once you do it, fixing a permanent fix to the problem is required.
Got it. And so quiet enjoyment, for all intents and purposes, has nothing to do with noise necessarily. There are other stipulations that mean quiet enjoyment, but is there a timeline that, needs to be assessed or addressed in order to make these modifications once a request is made? Obviously there needs to be potentially an architect that has to design building permits and then the actual construction. Are they putting any regulations on that currently, or is that something that's also a work in progress?
The question is, and we all know how hard and time consuming doing anything having to do with construction in New York City can be. So if the landlord turns around and says, well, I'm doing this and I'm doing that, I'll get to it in 3 years, then I think the Human Rights Commission would object to the landlord stalling and waiting for the people to die or leave. But if there's a major renovation, and of course local law 11 now has taken over all of our lives, and you have sidewalk bridges up around the buildings as we go through the 9th cycle, and somebody says, you have to take care of this particular problem for me, like putting a ramp in front of the building, you really can't do that while the building is under scaffolding and you're trying to get the local law 11 work done before the onset of cold weather when you can't do the work. So, but that would only buy you, but 6 months, 12 months while the work is being done. The problem for the landlord, excuse me, doesn't go away just because there's time to get the job done.
Mm-hmm. So are the boards allowed to charge an assessment for such accommodations, or is that?
Well, they could assess, but they'd have to assess everybody. In other words, they can't say to Mrs. Jones, we're going to have to spend $200,000 redoing the entrance to the building to accommodate you. Please send us a check for $200,000.
Right.
It would be assessed to all of the unit owners. It would be a common expense, and that's how it would be paid for. But if Mrs. Jones says, I want you to do something in my apartment, and the board decides, we will do that. And that gets us to an interesting question about grab rails and bathtubs and showers.
Right.
Then it's the shareholders' or the tenant's responsibility to pay to have it done, to have something that they want to have inside of their apartment. And based upon this law, the work has to be reversed when the tenant leaves. There's an interesting rule with regard to grab bars in bathrooms, which are critically important because it's so easy to slip in the bathtub. And that is that if a tenant requests a grab bar, the landlord has to install it, but at the tenant's expense, unless the building was first occupied, I think after 1991, in which case then there would have to be support behind the wall for the grab bar, and that would be the landlord's responsibility. And it's an interesting wrinkle having to do with the way pre-war and post-war buildings were constructed as to who's going to pay for a grab bar to have it done. Frankly, I think anyone past a certain age should absolutely have grab bars, because so many people slip and fall in showers and bathtubs that it's something that protects the landlord from being sued.
And right, it makes sense, and it's a danger. But to be clear, if a handicapped tenant is requesting the bathtub be replaced with a shower in a condo unit, then the tenant is responsible for the cost. And then if they add in the shower, or if they add in the bathtub, and the landlord would like to have it back to a shower, then the tenant has to do that. Is that the case?
Yes, but I'd be very surprised if the landlord wanted to convert it back again, because in the process, all the plumbing has been repaired or replaced, and it probably would be a major undertaking to reverse a bathtub that's turned into a shower back to a bathtub again.
Right.
Because it's completely different plumbing.
But it is possible, I guess, is the question.
Everything is possible.
There you go. All right, so now what about if a tenant's disability is requiring them to make noise that disturbs other tenants? Challenging.
You mean that someone has a mental issue that they have to sit in their apartment screaming all night long, or that they have to play extraordinarily loud music?
I guess.
That's a very interesting question. That I can't imagine that the landlord would be responsible for soundproofing the tenant's apartment so that their noise isn't disturbing anybody else. But I could see where the surrounding unit owners or shareholders would want that individual's apartment soundproofed so that their reasonable accommodation isn't affected.
So I guess in this case, it's Tourette's. The person mentioned it would be a Tourette's syndrome.
Yeah, I can't imagine. I could see where the other tenants in the building on the floor would claim that their quiet enjoyment is disturbed by this individual. I don't think that, and I could be wrong, and I apologize to anybody if this is a real life case. I can't really imagine that someone with Tourette's would call up their landlord and say, I have Tourette's, I'm going to be screaming, I want you to soundproof my apartment. I think it would be more likely that the other residents on the adjacent apartments would want the landlord to do something because the screaming is upsetting their quiet enjoyment of their apartments. I don't think I know the landlord can't, throw out the individual with Tourette's in order to reduce the noise in the building. That's discrimination. But the landlord might have to do something to calm down the tenants who are affected by the noise.
Yeah, interesting. All right, so now going back to the grab bar. In a building built after 1991, in a co-op building, if there is a shareholder that is requesting a grab bar, would the co-op, as the owner of the building, be responsible for the costs of the installation of the grab bar?
The co-op would only be responsible for reinforcing the wall in the bathroom that the grab bar is going to be on. They would
Okay.
not be responsible for any other renovation to the bathroom to accommodate it.
Got it. Thank you. All right. And now concerning roof decks, if you already have one that is accessible by stairs only, is there a consequence?
If for some reason the Human Rights Commission gets a complaint and goes up to the roof deck, they could close it.
Mhm. Okay.
Unless there's a way of accommodating the shareholder who's affected or providing an acceptable alternative for the shareholder who's not getting the benefit of the roof deck.
Got it. All right. And now in the case of
As a matter of fact,
sorry, yeah.
Elise, let me just say, as a matter of fact, we've had a number of situations over the years where buildings wanted to put in roof decks,
Mhm.
which they weren't able to do because there was no way to get the access to the roof deck handicap accessible.
Hmm.
And this isn't something new. This has been the case for 20 years or more.
Wow. So that is a major consideration of a roof deck, that if you
Yes.
do not have, if it's going to only be staircase accessible, this is important, I think, for people considering about capital improvements that they should think about. So Ajo, going to you, how should we, our clients expect the way that communication is going to unroll regarding the new regulations? I mean, we have been so fortunate to have Stuart here, and obviously we always want to help educate our clients as things unroll and unfold. But how should they expect this to come to them?
Sure. Clearly we are going to be staying close to this and in connection with industry experts such as Stuart. And as soon as the regulations are out, or even prior to that, if we get any additional information or courses of action that the buildings may need to take, we would certainly reach out to the boards with a summary of what it is, the actual law or regulations if they wanted to dig in, and then best course recommendations thereafter.
Mm-hmm. Great. And so we're going to be finishing this up for this evening, but we obviously understand that this is going to be, changing as weeks go on, and we encourage everyone here to ask us questions. I've included Stuart's staff's information. He's been fantastic. Thank you so much, Stuart. And Ajo, Korean, and myself, we're always here to help any way that we can help and advise you. So if you have any other questions, again, please feel free to email us, and I'll finish it off with the next few questions here. So regarding fire exits, if there's only stairs that seem to be alternating given the elevators, what do you do in the case of a fire, and how will that be made for an accommodation?
That's a very, very interesting question. And every building has to provide two means of egress from apartments in the event of a fire.
Mm-hmm.
And not infrequently, you will have the fire department do an inspection in the building and find that the two means of egress are blocked and put a violation against the building. And that's critically important. And in point of fact, the fire department has gone so far in the last couple of years that if they go through the building and they see that there are garbage cans on floors that are blocking or could block, in the event of a fire, access to the stairs, they will require that the garbage cans be removed so that they aren't an impediment. And then you get the issue of people who are storing baby carriages and other things in hallways. If the fire department does an inspection, they will require that all of those things be removed. I want to say two things before we're done for the evening. The first has to do with parking. If the building has a parking garage and an individual has a disability that requires that they have close proximity to their car, they can be put at the top of the waiting list if there aren't garage spaces available.
Hmm.
And the other thing is that I don't want to finish tonight without thanking you and everyone at AKAM for jumping on this as quickly as you have and providing a way to distribute this information on something that's so important to so many people in our community. So thank you.
Well, thank you. This has been extremely informative, and we really appreciate you for, you're just a wealth of knowledge. So thank you. And then Ajo, are there any closing comments you'd like to make, from an AKAM perspective, just again, to help our clients understand what to expect for next steps?
Sure. We'll handle keeping our clients posted in terms of updates and things like that, and putting in any necessary protocols and procedures around the new regulations. And also, as Stuart just mentioned, keeping in mind the sensitivity around this for those requesting reasonable accommodations and being sensitive to that, because we are, every building has its own building community. And we want to be respectful for everybody's needs in that community.
Mm-hmm. Makes sense. Well, thank you, Ajo. And thank you, Stuart. And thank you all for your time tonight. Please, again, we understand this is definitely a lot to digest. So we're happy to help you with any questions that you have. Please feel free to email us at any time and we will get right back to you. And we hope to have you come back and join us for the next one. Have a great night, everyone. Thank you. Be well. Bye.
Thank you, Stuart.
Thank you, Stuart. Thanks,
Have a
Ajo.
good night.
Good night.